Good afternoon. I'll give it a few seconds for those to join in. Okay. Good afternoon. My name is Lucy Delgadio. I am the Director of Advocacy and Organizing for the League of Women Voters of New Jersey. Thank you for joining us today. Some housekeeping rules before we get started. Our chat for today's event is disabled. We will hold a Q&A session at the end of our panelist discussion. Please type your questions and we will do our best to answer all the questions that come in. In a 2012 speech, Congressman and civil rights activist John Lewis said, "My dearest friends, your vote is precious, almost sacred. It is a most powerful nonviolent tool we have to create a more perfect union." Representative Lewis' ideas of vote as a sacred franchise that can make a difference is becoming closer than ever to reality in New Jersey. Today, July 17, 2024, marks the 4th anniversary of the death of the late Congressman John Lewis. With the ongoing attack on our democracy, today's webinar will highlight the urgency of this moment in history. Our intention is to educate, motivate, and activate our communities to work towards the passage of the John Lewis Voter Empowerment Act of New Jersey, A4 4083 S 3009, a powerful state voting rights act. You will hear from leaders of the NJVAR coalition representing the New Jersey Institute for Social Justice, the NAACP Legal Defense Fund, the ACLU of New Jersey, and the Asian American Legal Defense and Education Fund. It is my honor to introduce our panelists, Nuzat Chowdhury, Senior Counsel, Democracy and Justice Program with the New Jersey Institute for Social Justice, Michael Pernick, Redistricting Counsel of the NAACP Legal Defense Fund, Liza Weisberg, Staff Attorney, ACLU of New Jersey, and Ronak Patel, Equal Justice Works Fellow, Asian American Legal Defense and Education Fund. Each panelist will address pertinent components of the legislation and how we can get NJVAR closer to becoming reality in New Jersey. So let's get this started. Michael, can you please explain to us what the campaign to pass state John Lewis Voting Rights Act looks like across the country?
Absolutely. Well, first, before I dig in, I'll introduce myself. My name is Michael Pernick, pronouns he, him, his, and I'm an attorney with the Legal Defense Fund. Lucy, thank you so much for bringing this group together, for hosting this very important event. I'm grateful to the New Jersey League for leadership on democracy issues and especially your leadership and work to champion the New Jersey Voting Rights Act. So I was asked to give an overview on state VRAs across the country, but I'm actually going to start not by talking about other states, but by talking about the Federal Voting Rights Act. As I'm sure some folks may recall, the Federal Voting Rights Act, which was enacted in 1965, was and remains to this day, I believe, the most powerful and significant civil rights law adopted in our nation's history. It was adopted in response to truly horrific racial discrimination in voting across the South and established crucial tools to combat racial discrimination in voting all across our country. Section 2 of the Federal Voting Rights Act created a new private right of action to give voters their day in court when they face racial discrimination, when they face redistricting plans that harm voters of color, or if they face severe voter suppression that makes it more difficult to participate and cast a ballot at the ballot box. It also codified into law Section 5 of what we refer to as the pre-clearance program. And this was a really innovative and sweeping program that required jurisdictions, states, and local governments with a history of racial discrimination in voting or other red flags of voter suppression to get pre-approval before they can make any changes to their voting rules to make sure that those changes don't make voters of color worse off. Section 5 was referred to as the shield to prevent bad changes from going into effect. Section 2 was the sword that gave voters tools to go to court and challenge racial discrimination in court. And together, these components created very powerful tools to combat racial discrimination in voting. Unfortunately, over the last 10 years or so, we've seen some severe erosion of these crucial tools. In a 2013 Supreme Court opinion, Shelby County versus Holder, the Supreme Court rendered Section 5, that pre-clearance program, entirely ineffective by striking down the formula to determine who would be covered under the pre-clearance program. And after the Shelby County opinion removed those protections requiring pre-approval before changes to voting rules could be put into effect, we saw a flood of voter suppression legislation. Over 1,000 polling places across the country have been closed in communities of color. We've seen a real erosion of many of the hard-fought gains for communities of color when it comes to right to vote. Section 2 is still available, the sword, but it's been weakened and scaled back. In a 2021 opinion, Brnovich v. DNC, the Supreme Court imposed what they call a set of guideposts that limit Section 2 claims challenging vote denial or voter suppression. But these guideposts have rendered Section 2 entirely ineffective when it comes to vote denial. There hasn't been a single successful voter suppression or vote denial claim since that opinion. And it's really constrained the ability of voters of color who are facing voter suppression to use the Federal Voting Rights Act to vindicate their rights. So as we've seen this erosion, and we've seen an increasing number of states and local governments across the country engaging in voter suppression or maintaining structures of elections and practices or procedures that are racially discriminatory. At the same time, we've seen an encouraging trend of an increasing number of states enshrining state-level voting rights acts that are informed and inspired by the Federal Voting Rights Act of 1965, but updated to respond to the threats that we face today and bolstered to ensure that they're comprehensive at responding to everything from voter suppression to racial vote dilution, discriminatory redistricting. So we've seen this encouraging trend, and in the last several years, there's been an explosion in interest from well-intentioned policymakers, advocates, legislators across the country in introducing and championing and enshrining state VRAs into law. In fact, I would say that adopting and enshrining a state VRA is the single most important thing that a state legislature could do to protect our democracy and ensure that voters of color have tools to combat racial discrimination in voting. We saw the first state VRA actually adopted back in 2002 in California. It was very limited, but very important. It allowed voters of color to challenge in court at-large local elections that were discriminatory. So imagine a county or a city or a town that was, let's say, 30% Black and 70% white, and they used what are called at-large elections. So every single voter participates in voting for every single seat. And because of the population breakdowns, we see Black voters often entirely shut out of having any representation because the 70% white population would consistently deny Black voters that equal opportunity to elect candidates of their choice. The California Voting Rights Act and every Voting Rights Act since then has made it easy for voters of color to challenge those sorts of structures in streamlined, efficient ways. Now, those claims can be brought and are brought under the Federal Voting Rights Act, but the litigation under the federal VRA is complex and takes a significant amount of time. And California wanted to enshrine state-level protections to make it easier for voters of color to protect their rights. We saw more recently similar state VRAs in 2018 and 2019 adopted in Washington and Oregon. In 2021, Virginia adopted a more comprehensive state VRA. And in 2022 and 2023, New York and Connecticut each adopted the most comprehensive state VRAs we've seen to date. And the New York and Connecticut models are very similar to the model that has been introduced and is pending in New Jersey right now. That model has 6 main parts. So it includes an analog to Section 2 of the Federal Voting Rights Act, tools to go to court to challenge racial discrimination. It includes an analog to the pre-clearance program, procedures to ensure that jurisdictions with a history of racial discrimination in voting are required to get pre-approval before making changes to voting rules. It includes tools to combat voter suppression. It includes an expansion of language access. It includes protections against voter intimidation, voter deception, and voter obstruction. It even includes procedures to consolidate data that's necessary for elections, create a statewide database of election data to allow stakeholders and advocates to understand best practices and identify when there are structures in place that are racially discriminatory. So those models are really exciting, really comprehensive. And just a couple of months ago, the state of Minnesota passed its own state VRA, which is great. The Minnesota VRA, it isn't quite as comprehensive as the New York and Connecticut model, but includes crucial protections that are especially important in a state like Minnesota. So this is really exciting that there's been so much momentum. And in the face of, I mean, I'll just be real, we're in dark times right now. We're in tough times right now. And in the face of these challenges that we're facing at the national level, political gridlock, Supreme Court that's eroding these rights. One area that is giving me some hope is this increasing momentum around state legislatures enshrining these important protections into state law. So obviously, we're here today to talk about New Jersey, but New Jersey isn't alone. There are active efforts to pass state VRAs right now in Michigan and Maryland. A comprehensive bill was introduced in Florida, and there's interest from other southern states in introducing bills as part of a long-term strategy to hopefully pass a state VRA in a southern state if political dynamics shift at some point in the future. So there's real momentum around these provisions, and we've seen since 2018 a new state VRA has been adopted every single year in a different state, except for 2020, where we were dealing with that little pandemic thing. Every single year had a new state VRA adopted, including this year's win in Minnesota. So there's been a real sense of momentum and a lot of interest from folks across the country in creating these powerful, crucial tools at the state level. So you'll hear from these amazing panelists. It's an honor to get to work with everybody on this panel on this legislation. So you'll hear from my colleagues about the need for this bill in New Jersey and some of the most important, most powerful provisions. But I'll just say thank you again, Lucy, for having me, and I'm looking forward to a very robust and interesting conversation. Thank you.
Thank you so much, Michael. Now we're going to move on to Nuzat. Can you please tell us the status of NJVAR today and how it's so necessary to have it implemented in the state of New Jersey?
Yeah, absolutely. Thank you again for organizing this, Lucy, and having us. My name is Nuzat Chowdhury. I'm senior counsel with the New Jersey Institute for Social Justice. And I lead the NJVRA Coalition, which is a very robust and very active coalition of partners, such as those you see on this call, really seeking to push and try and get New Jersey to pass a strong Voting Rights Act to protect New Jersey voters. So currently the NJVRA has been introduced. It has a bill number, it's A4083, S3009, as Lucy mentioned, sort of at the top of the webinar. And we are really wanting to make sure that the bill is heard in committee. That's sort of what we're doing. That's our big push right now for the coalition, is to make sure that the bill is heard and then goes through the different committees and hopefully with pie in the sky goal of getting it passed, by the end of this year, next year at the latest, but definitely, we want to see action on this. We want to see movement. And the reason is it's incredibly important right now, at any time really, but especially right now for New Jersey to protect voters, and particularly voters of color. So, I mean, as Michael mentioned, democracy is so clearly under attack right now, on the federal level, sort of across the board. And with democracy being so clearly under attack, I think it's easy to think that we're okay here in New Jersey, right? New Jersey is one of these states where that's often viewed through the lens of blue state, or a state that generally passes strong voting rights and democracy policies. And generally speaking, that's not untrue. But it's easy to say that voter suppression and attacks on democracy don't exist in New Jersey because it doesn't look as obvious as it does in some southern states or red states, if we want to describe them as such. But just because New Jersey hasn't passed line warming bans or restricted the right to vote through state law yet doesn't mean that we have a truly equal or accessible or even inclusive democracy, right? Not all voters are able to access the right to vote in the same way in New Jersey. And that's important because what that means is that for some voters and some voting communities, it's harder for them to vote. And that is a form of voter suppression, even if it doesn't look sort of the way that we're used to or that we see in the media. So for anyone who knows any New Jersey history, this actually shouldn't be too surprising, because even though New Jersey is now one of the most diverse states in the entire country, with almost half of the population being Black or people of color, New Jersey has a strong history of voter suppression. So the original Constitution in New Jersey in 1776 had no restrictions. It gave the right to vote to all people who lived in New Jersey, regardless of color or sex. But in 1807, the legislature restricted that right to vote to only tax-paying white male citizens. And then the state restricted the right to vote even more in 1844 by prohibiting folks with criminal convictions from voting. In a state such as New Jersey, with one of the highest racial disparities in the incarcerated population, basically what this meant is that Black and brown folks have been disproportionately disenfranchised by that 1844 law, in particular. And it wasn't until 1870 and Congress passed the 15th Amendment that New Jersey gave the right to vote back to Black New Jerseyans. And it wasn't until 2019, in fact, 175 years after that 1844 law, that New Jersey law finally restored the right to vote to more than 83,000 people who at that time were on parole or probation. So what this history shows really is that voter suppression isn't something that is only a problem or a threat in red states or southern states. It very much has a home and a history in New Jersey as well, which is why something like the New Jersey Voting Rights Act is so important to consider and to pass, to protect voters from something like that and going back to voter suppression in those forms or in other insidious forms that we see. So in general, New Jersey has made great pro-democracy progress over the past handful of years. As I mentioned, in 2019, the state restored the right to vote to those on parole or probation. We've also expanded access to the polls by doing early voting and automatic voter registration and online voter registration. And we have a very strong and expansive vote by mail system. These are all excellent steps toward creating a stronger democracy, but there's much more for us to do, especially because there are chronic and really persistent issues that we see in New Jersey when it comes to voting specifically. So New Jersey voters, and especially voters of color that come from communities of color or cities that have a disproportionately that has a high population of Black or brown voters, these voters still face obstacles every single year when they go to the polls to vote. And these obstacles come in forms such as delayed openings of polling locations, long lines at polling locations, lack of signs and accessibility for voters with disabilities or medical conditions, lack of language accessibility for those voters who maybe don't speak or read English very well. We see voter registration problems. We see lack of access to courts for disenfranchised voters. And these things really accumulate, right? So they might not look like voter suppression in the traditional sense, but at the end of the day, the result is the same. Voters, and especially voters of color in these communities and cities of color in New Jersey, when they find these obstacles standing in their path to voting, it makes it much harder for them to cast their ballot. And if someone can't cast their ballot easily because they can't read it in their language, or they go to the polls in the morning before work and it's just not open yet, or they come home from work, from a long day at work, and they have to wait in line for 2 hours just to vote. These things turn voters away. It makes it much harder for New Jersey voters to vote. And sometimes it makes it so that those voters leave without voting altogether. And that is voter disenfranchisement. That is a form of voter suppression. So these are problems, these are the chronic challenges that New Jersey voters face even today. And that's why we need a way to protect those voters, to make sure that access to polling locations is equitable and inclusive to all voters across the state, no matter what background they come from, and making sure that New Jersey voters in particular have the legal tools to address those obstacles, even if they continue to persist. And that is what the NJVRA is for. That's what the coalition is advocating for. And that's why we're here today to talk about it. So thank you again for organizing this, Lucy, and I'll pass it back to you.
Thank you so much for everything you said, and it's so important. Now we're going to move on to Ronak. So Ronak, could you explain to us, please share the key elements surrounding voter suppression, voter dilution, and language access?
Of course, and thank you so much, Lucy, for organizing this panel. As Michael and Nuzaf illustrated, our democracy is under sustained attack. New Jersey isn't immune to this and itself has a history of voter suppression and vote dilution. At the federal level, we've seen the Supreme Court and Federal Appeals Court chip away year after year, decision after decision at the Voting Rights Act, as well as other federal protections for all voters, and especially voters of color. This has all weakened our ability to fight against voter suppression, vote dilution, and to ensure that we have a free and open democracy for all of our citizens. The New Jersey VRA approaches this problem in a lot of different ways, but I'm going to talk to you a little bit about voter suppression, about vote dilution, and about expanded language access. On the voter suppression front, we've seen a rise in voter suppression laws across the nation. There are practices that are employed in this state by counties and by the state writ large that have resulted in differential rates of voting among people of color versus white communities. And so the New Jersey VRA really takes this issue and does two things. First, it codifies federal law. It takes what has come out of Section 2 of the Federal Voting Rights Act and makes a clear standard that the court avoided laying out in Brenovich, as Michael was talking about, and lays out a clear standard as opposed to these ambiguous guideposts that will allow plaintiffs to have their day in court, to say, my vote is being suppressed because this policy or this practice that is being employed disproportionately harms voters of color. The New Jersey VRA lays out this standard, but also points to certain things that would make out a presumptive case of voter suppression. These are things like changing polling sites in a way that harms voters of color, moving out or closing ballot drop boxes in a way that harms voters of color. And so this enables voters to both bring a private suit that is easy for courts to actually understand and to litigate, as opposed to the federal standard, which is this ambiguous guidepost-based practice that has unfortunately resulted in not many, if any, plaintiffs being able to fight voter suppression laws since Brenovich came down. On the other front, vote dilution is something that's been in the news, especially more recently with these ongoing cases in southern states. But vote dilution is not just a southern issue. It's actually one of the more common issues we see in local and school board elections, where traditionally many of these elections have been at large. And as Michael was laying that out earlier, these are elections where every resident within the jurisdiction, whether that's in the school district or the town or city, gets to vote in one big election and they vote for their candidate. And as such, when you have a town or a district that is majority white and there's racially polarized voting, minorities don't get a voice in who actually gets elected and who represents them, whether at the city council level or in the school board. And so the New Jersey Voting Rights Act, building upon work in other states like New York and Connecticut, as well as California, the progenitor of all of these voting rights acts, seeks to lay out a clear standard that makes it easier and simpler for plaintiffs to bring these types of claims, clarifies what sort of evidence that they need to show, as well as lays out some requirements for courts that makes it easier for those courts to give relief, and also lays out ways in which the court can pick a remedy that benefits minority communities and implement that remedy. So one of the key ways that the New Jersey VRA would differ from the federal VRA when it comes to vote dilution that really will help New Jersey, because it is such a diverse state, is not requiring that plaintiffs show that they can draw a majority-minority district. And so these are these traditional districts where the minority group makes up more than half of the population so that they can elect their candidate of choice. In places across the state in New Jersey, you don't often always see this. You see, especially in growing Asian and Latino communities, very mixed and coalition-based districts where an individual minority group might not reach 50% in an electoral district. But if you are able to create a new type of election remedy like ranked choice voting or cumulative voting, they would have equal opportunity to participate as much as white voters do. And so this is a key way in which the New Jersey VRA expands upon protections of the federal VRA when it comes to vote dilution. One of the other key pieces where the New Jersey VRA will expand the federal VRA is in terms of language access. Understanding the electoral process and balance is extremely imperative to effectively voting. If you don't understand how to register to vote, where your poll site is, when election day is, or who's on the ballot, you're not going to be able to effectively vote. As many of you know, New Jersey is an extremely diverse state. It is an immigrant state where millions of our citizens are naturalized citizens who many of times do not speak English very well. They're limited English proficient or LEP. That means for these voters, English-only elections kind of deny them the access to the ballot that folks born here and who can speak English fluently and very well, their equal rights. So under federal law, there's something called Section 203 of the federal VRA. That has granted some New Jersey residents access to language assistance, whether in the form of translated materials or interpretation at the poll sites. The federal VRA, again, has very high thresholds of what a population needs to look like to have language access required in that jurisdiction. Right now, only a few counties in New Jersey are covered, and for a limited set of languages. The New Jersey VRA would expand language assistance to more voters in a couple different ways. First, it will lower those thresholds so that more counties are required to provide language assistance. Second, it clarifies specific languages that the assistance needs to be given in. So under the federal VRA, it does it by language minority group, which oftentimes is ambiguous as to which language to provide assistance in. For example, Middlesex County is covered for Asian Indian, but as many of you know, Asian Indians speak a variety of different languages. Under the New Jersey VRA's thresholds and formula, it will specify which exact Asian Indian language the jurisdiction would need to provide assistance in. It also clarifies what type of assistance needs to be provided. Are we talking about just translated materials? Are we talking about poll workers who speak the language? Do we need dedicated interpreters? And it spells that out in an unambiguous way, clarifying some ambiguity that's been working through the federal courts and the federal VRA. So what the NJVRA does is really plug the gaps in the federal VRA that both Michael and Nuzat were talking about, and then expands language access to potentially millions of more voters in New Jersey who are limited English proficient.
Thank you so very much for that great explanation. And now on to Liza. Liza, could you talk to us about the pre-clearance process?
Yes, absolutely. Thank you so much, Lucy, for convening us all here together, and thanks to my fellow panelists who are just the best collaborators. I was so excited when Lucy said that I would get the pre-clearance section, because I think pre-clearance is the most exciting part of the New Jersey Voting Rights Act. I love all of the bill, but I do think that the pre-clearance system that this bill sets up would be just tremendously impactful in New Jersey. So I'm going to go back a little bit and retread some of the context that Michael provided, because I think it's important, and I see some new people have joined since he started talking. So when the Federal Voting Rights Act was passed in 1965, the centerpiece of that legislation was this novel and unique pre-clearance system. And under the Federal Voting Rights Act, states and localities that had a history of racial discrimination in voting were required to submit new voting and election laws to the federal government for review before those changes could go into effect. And then it was the federal government's job to take a look at those new proposed laws and examine whether they would harm voters of color, whether they would be discriminatory either in their intent or their effect. And if they were, then they would, get sent back, and the federal government would say, try again. They wouldn't harm voters of color, then at that point they could go into effect. And so what's really powerful about that is it stops these harmful discriminatory laws before they can actually affect voters. The sort of affirmative tools, the voter suppression and vote denial tools under Section 2 of the Federal Voting Rights Act, and that Ronak talked about a little, absolutely essential too, but those, put the burden on voters or advocacy groups or the government to sort of be monitoring laws all over the place, and then to mount expensive, time-consuming, costly lawsuits in order to challenge laws that are discriminatory. And then it's up to the voters, or the folks representing them to prove that case. Whereas in the case of pre-clearance, the burden is on that jurisdiction that's trying to implement a new law to prove to the government that that law won't cause harm. And crucially, again, you don't have to wait for litigation to unfold, for all this harm to be ongoing before you can address that discriminatory practice through pre-clearance. Sadly, as Michael mentioned, in 2013, the Supreme Court in Shelby County v. Holder effectively axed pre-clearance under the Federal Voting Rights Act. So they did that by invalidating the coverage formula for pre-clearance. That was a sort of set of criteria that would determine which states and localities would be subject to the pre-clearance regime. And the sort of undercurrent of the opinion there was times have changed, racial discrimination in voting, not such a big deal anymore, let's move on. And of course we know that that's not true, right? And we also know that so much of the progress that we've seen in voting and in making voting more accessible was thanks to the Voting Rights Act. And so famously in a dissenting opinion in that Shelby County opinion, in the Shelby County case, Justice Ginsburg said, I'm paraphrasing, getting rid of pre-clearance when it's been working is like throwing away your umbrella in a rainstorm because you're not getting wet. And sadly, that sort of has proved a prophecy. And as Michael said, as soon as we saw pre-clearance evaporate in 2013, states all across the country unleashed a torrent of voter suppression laws. And it's been just really hard to attack and combat those laws with the remaining tools of the Federal Voting Rights Act ever since. And so what this New Jersey Voting Rights Act would do would create a sort of analogous pre-clearance program tailored to the unique needs of New Jersey. And so just like in the federal system, under the New Jersey law, there would be a sort of coverage formula that would bring certain jurisdictions in the state under the pre-clearance system. And those states would then have to submit certain changes to their voting election procedures to, in this case, the Attorney General, for review, for a double check to make sure that they wouldn't cause harm to voters of color, or they could go into effect. So the coverage formula in New Jersey takes into account parts of the state that have had a history of civil rights and voting rights violations, and also patterns of segregation and racially disparate arrest and poverty and election participation rates in the state. So it's a system that's closely tailored to New Jersey's needs, and would be a huge boon to voters and advocates and communities in the state. And I'll pass it back to Lucy with that.
Okay. So thank you all for sharing all your knowledge and wisdom when it comes to NJVRA. But I have one simple question for all of you. And what will happen if it doesn't get passed? What is at stake from every walks of what you all described right now? And I'll start with Michael. What will be at stake if New Jersey does not decide to pass NJVAR?
Well, we see a number of ongoing and continued assaults on the Federal Voting Rights Act, making their way through circuit courts right now. In the Eighth Circuit, there was a recent opinion holding that voters don't have a private right of action under the Federal Voting Rights Act. That opinion hasn't been appealed, but that similar argument has been popping up in other places as well. So there's a risk that at some point in the future, New Jersey voters could lose what few protections we still have under the Federal Voting Rights Act. If that line of attack from opponents of the right to vote continues to have success in courts. In the Fifth Circuit, there's ongoing litigation over the question of whether voters of different racial groups are allowed to band together to bring what are called coalition claims. So if Black voters and Latino voters are both suffering from racial discrimination in voting, are those groups allowed to bring claims together? And that's very important because sometimes the only way for you to prove that there's a violation is if two groups can show that together they are denied that opportunity to participate in the political process equally. There's a circuit split right now over whether those claims are viable, and we see continued efforts to limit those sorts of theories, which are especially important in a place like New Jersey, which is an extremely, I think New Jersey is the most diverse state in the country, I think. So we see these ongoing threats in federal courts that are happening right now. And the New Jersey Voting Rights Act provides such a crucial opportunity, a moment to enshrine these core protections into state law and to dramatically bolster them for New Jersey voters. So it'll not only be a sorely missed opportunity, but it'll allow New Jersey voters to continue to be exposed and become exposed to even more severe forms of racial discrimination in voting. And this is so crucial at the local level, so crucial even in a state like New Jersey at the local level, where there's a risk of racial vote dilution with local at-large elections, with redistricting plans, with decisions about where polling places go. So there's risks, increasing risks, and this is such an important moment and opportunity to enshrine these protections into state law. I also know that folks from New Jersey tend to be competitive, and it's the only state in the tri-state region to not have a state VRA. So I would encourage folks in Jersey to really do everything possible to advocate for this bill so that New Jersey voters and voters of color especially have the same protections that their neighbors in New York and Connecticut certainly enjoy.
Thank you, Michael. Liza, do you want to take a crack at what pre-clearance would be at risk?
Yeah, sure. So, without pre-clearance, we'd essentially be where we are right now, which is that there's a huge strain on advocates and voters to try to pay attention to changes all up and down the state that affect voters' rights at the polls. For example, in 2020 was the first redistricting cycle since the passage of the VRA without the protections of pre-clearance. And it meant that that advocacy groups were working 24/7 to try to pay attention to changes in local redistricting maps at the school board level, at the municipal level, at the county level, at the state level. It's just simply impossible. And the reality is you cannot accomplish all the important work of making sure that things like new redistricting plans that are so essential will comply with the law, will not be dilutive, will not impact voters' rights to exercise their political power at the polls without a system like pre-clearance. So if we don't have pre-clearance, for example, going into the 2030 redistricting cycle, it'll be up to voters and advocacy groups, and we're up to the task, but it's not easy. It'll be up to us to be paying attention to the hundreds of processes unfolding at a local level to draw new redistricting plans. And the reality is that there will be discriminatory plans that slip through the cracks that we can't identify, that we can't take action on. On the other hand, if there's a pre-clearance system, it'll catch the worst of the worst, right? It'll mean that the state government, the Attorney General's office, will be equipped to be monitoring the jurisdictions that fall under the coverage formula, the covered jurisdictions, and they'll be able to pay attention to the new redistricting plans and halt the discriminatory ones before they can go into effect. So it would make a huge difference to have that kind of protection going into 2030, but also, every day that that states that jurisdictions in the state are making changes to election procedures, like even doing something as simple as changing the number of polling places in a community can have a huge impact on on the ability of communities of color to access the polls. And it's just essential that we have a system in place to catch harmful and discriminatory practices before they can harm voters.
Ronak, do you want to take your answer the question? What with all the what you discussed, how much harm would it cause?
Yeah, I would definitely like to echo what Liza and Michael were saying. The presence of pre-clearance really filters out the worst of the worst, as Liza was saying, and makes this less of a game of whack-a-mole. As you all know, local governments tend to be the most opaque. They tend to also have the most power to control our daily lives. They control the quality of education our kids get, the quality of local infrastructure dollars, among other things. And so having clear causes of action for individual voters to combat those things that don't come up on the AG's radar through pre-clearance is imperative. So we need clear a clear ability for individuals who are being harmed by poll site consolidation, drop box moving, things that oftentimes are done very quickly without a lot of notice. They need an ability to fight against that. And those changes and those suppressive practices disproportionately impact LEP voters, those who don't speak English very well. And so the language access component of the New Jersey VRA is also extremely important to expanding access to the ballot and effective access to the ballot, because the right to vote only matters insofar as you're actually able to cast a ballot that reflects what you want. And so New Jersey VRA's expanding of access to voting materials and translation and interpretation in your native language is going to be really important going into the next election and to the next redistricting cycle, where you want to see all citizens turn out to vote if that's what they want to do. We see across the country and in New Jersey, folks who are naturalized and who do not speak English very well are much less likely to vote. But once folks start voting, they don't stop. And so it's really important as folks become new citizens that we include them in our body politic, in our democracy. And it really starts by making sure that they feel like they're equipped to go cast a ballot, whichever way they want to go cast it, whether it's by vote by mail or in person or early.
Thank you so much. Nuzat, do you want to answer?
Yeah, I'll just my colleagues have really covered the large chunk of this question. I think what the one thing I'll add here at the end is that, you know, as Michael said, sort of when he was explaining the background to the federal VRA, right? The federal VRA really was a seminal piece of really effective civil rights legislation. It's, you know, it was meant to protect Black and brown voters in particular, because Black and brown voters were historically facing so much discrimination at the polls. And as I mentioned, that's not a history that is that missed New Jersey. New Jersey was also very similar. So if the federal VRA does fall, I mean, I think that's the body, that's civil rights legislation, that's protections to these groups of people that there's now a vacuum there. And so I think that really is the heart of it. All of the things that Michael and Liza and Ronak have been talking about, the heart of what we would be missing if we don't pass the NJVRA and the federal VRA falls is that protection for these communities that are very chronically disenfranchised and have been for years and years. So we need legislation on the state level to protect these communities, to protect these voters, because if the federal legislation no longer protects us, we can't rest on Congress to protect us. We can't rest on the Supreme Court to protect us. New Jersey is going to have to protect New Jersey voters. And that's what the NJVRA does. And that's why it's so critical to make sure that we do everything we can to pass this and to make sure that our legislators know that New Jersey needs to vote to protect New Jersey voters. And this is one of the biggest tools that we have to do it.
So we have a few questions that came in. The first one is, how can we pass gerrymandering be considered in any pre-clearance or any aspect of the NJVRA? And whoever wants to take that one.
Go ahead, Michael.
Okay, well, I'll say the improper manipulation of district boundaries at the local level is such a perverse and systematic problem across our country. And the New Jersey Voting Rights Act would create two distinct powerful tools to combat racially discriminatory or dilutive manipulation of local districting boundaries. So to give an example, imagine there's a Black community that's sufficiently large to elect a candidate of their choice, but that Black community is cracked into two separate districts. That's dilutive of the power of Black voters. Imagine a different scenario. Let's say Black voters are large enough that they could elect candidates in two districts, but Black voters are packed into primarily one district at very high levels, and they might be able to elect one candidate to a local legislative body, but would be unable to elect a second candidate of choice. That's packing. It's another form of racial vote dilution. The New Jersey Voting Rights Act would combat these practices at the local level in two ways. So first, as Ronak talked about, it creates a state level private right of action against racial vote dilution. So if there's a local redistricting plan that manipulates boundaries in a harmful way to voters of color, this gives voters their day in court to challenge that plan and get it struck down and replaced with a new plan that is fair to voters of color. Second, as Liza talked about, there's this pre-clearance program. So local redistricting plans would be reviewed by the state before they can go into effect. And if the state determines that the local redistricting plan would be harmful to voters of color, and by the way, as Liza said, this only happens in certain select jurisdictions with a history of racial discrimination or other indicia or red flags of racial discrimination in voting. But in those jurisdictions, if they try and adopt a local redistricting plan that violates the standards in the New Jersey Voting Rights Act, or makes voters of color worse off than the previous plan, it could be barred from going into effect, and there would never be any need to litigate. The New Jersey Voting Rights Act does not reach state legislative redistricting. On the redistricting side, the focus is on redistricting at the local level, which, as others have said, is just so instrumental and monumentally important for representation and the right to vote, and the representation that we have in our local government.
Yeah, and so I would just add, so the question also asked sort of about how past gerrymandering could be considered in pre-clearance. And so what I would say is that if there is a local government in New Jersey that has been found in the past to, by, a court has said that this local government engaged in race-based gerrymandering or had a dilutive redistricting plan, that ruling would be captured most likely by the coverage formula and would bring that local government under the pre-clearance system, meaning the government would have to submit new redistricting plans, future redistricting plans to the Attorney General before those plans could go into effect.
Okay, and Michael, you touched base a little bit on when you answered your question, but the question is, will VRA make municipal redistricting more transparent to the public, and how?
Yeah, I mean, in terms of transparency, I think the one part that is really worth lifting up is the new statewide database, which is part of the VRA. This is a crucial part of the bill that's modeled on a similar database that was recently adopted in Connecticut. There's a similar database that was just passed in New York and several other states like California. And basically what it would do, it would require every local government to provide a whole range of data to the centralized database administered ideally by an academic institution. So it is insulated from the day-to-day pushes and pulls of politics, and every local government would be required to provide everything that's relevant to voting, elections, and redistricting. So that includes the plans, it includes shape files or block equivalency files, it includes all of the data that's relevant for this process, and it'll all be uploaded into a central database and made public. So it would be as much transparency as is conceivable, and it'll really enable advocates, experts, stakeholders to evaluate what's happening in our local governments when it comes to elections and our democracy and the right to vote. It'll enable research and scholarship and analysis of best practices and what works and what doesn't work when it comes to local government election administration and redistricting. And it'll enable communities that might be underserved or might be victims of some of these new protections that we have to actually evaluate whether redistricting plans or polling place locations have a racially discriminatory effect, so that those communities have an opportunity to get relief. Because we find as a litigator and someone who investigates voting rights violations across the country, one of the most significant barriers to identifying and pursuing violations is having transparent data and information about what's going on. And the database portion of the bill will be designed to address just that problem.
I'd also add one thing to Michael's excellent answer there, which is that so redistricting in general in the state is very much the state constitution goes really into how state redistricting, like the public hearings and how transparent the entire process of redistricting should be on the state level. So what the NJVRA does is also extends that. There's a provision in the bill that extends that to local municipal redistricting as well. So just to make sure that the process of redistricting is also transparent, so making sure that as redistricting is occurring on the municipal level, there are hearings that the public can submit comments to make sure that their opinions are and notes are being considered as localities do municipal redistricting. So there is a portion of the NJVRA that does address that to make sure that there is just greater transparency and feedback in local redistricting process.
And while I have you on the screen, I'm going to ask you, how could attendees get more involved, and how could they be part of the coalition?
Yeah, absolutely. So as I mentioned, we work in coalition with a lot of really excellent, very robust members who have been doing the work of making sure that the language of the bill was really as strong as it could be, and meeting with legislators, making sure that the public is being educated about the VRA. League of Women Voters and Lucy, organized this webinar so that we could be educating folks and getting the word out about A4083. So if you or your organization are interested in joining the coalition itself and joining us doing things like events, lobby days, legislative meetings, things like that, please reach out to me. Lucy's put a slide on the screen, so you can reach out to me to join the NJVRA Coalition. We have a listserv. I'm very happy to add you to it. You will receive emails from me monthly about the meetings and other actions that we're taking. So very happy to have your partnership in the coalition itself. But on an individual level, or if you're in an organization that has membership who are willing to reach out to your legislators, I think at this point, one of the biggest things that we need to do is make sure that legislators know that A4083, S3009 is something that is important, that this isn't something that is coming only for advocates or only from folks who care specifically about voting rights. This is legislation that the public wants, that we want, because we want to protect our right to vote. We want to protect our communities. So if you go to this we have a VRA website, which you can go to njvra.org. On that website, you will find what organizations are currently in the coalition. You'll find we have a report that came out last year. We'll have our report there. We have op-eds that we've done. Any big actions that we've taken will be updated to the website. But you can also go to this particular link, which is njvra.org/support-a-NJVRA. And we have what we call a phone to action there, where if you fill it out, you can send an email to your legislator, you can call your legislator. If you want to tweet at them, I think one of the things that we really want to be doing through the rest of the summer and going into the legislative session in the fall is making sure that we're louder, that legislators know that this is a campaign that is active, that we in our communities very much support the need for an NJVRA, and that we're demanding, we want to get this done by the end of this year. So please use your networks to spread the word. Please call your legislators. And of course, if you have an organization that would like to join the efforts, please reach out. And similarly, we're happy to come and do any sort of events. We're happy to speak to your membership organizations. We're happy to come table. We really are, we're trying to expand, and we have a really excited and enthusiastic group of democracy and voting rights enthusiasts who are willing to get this work done. So happy to come to you or help in whatever way we can.
Okay, and with that, we're at time. I wanted to say thank you to all the panelists. Thank you so much for being here today. If you did register for today's webinar, we will send you the one slide with the information of how to join the coalition and what you could do. Again, thank you today for joining today's webinar. We would like to extend our gratitude to our coalition partners, the New Jersey Institute for Social Justice, the NAACP Legal Defense Fund, the ACLU of New Jersey, Asian American Legal Defense and Education Fund. We also have partners with the New Jersey League of Conservation Voters and the New Jersey Black Empowerment Coalition. We appreciate you taking the time to join us today and hope you have an amazing day. And thank you.